Hello, and welcome to the State of Affairs in the Accounts Receivable Management Industry, a strategic review of compliance in the industry. This is part 2 of a 3-part webinar series hosted by Kaulkin Ginsberg Company. The first part focused on industry trends and M&A developments, and the last part will focus on technology. Before we begin, we'd like to thank you for attending. We know you're busy and time is valuable, so thank you for being here. My name is Kelsey Flinko, and I will be your meeting manager for today. Now I have a few housekeeping items to address before we get started. You'll notice the phone lines are muted. Should you have a question, please submit it in the questions box, and we will answer it during the dedicated Q&A session at the end of this webinar as time permits, or we will personally reach out to you with an answer after the webinar ends. Second, I have a disclaimer that I need to read, so bear with me as I read it on your screen. This information is not intended as legal, financial, or advice of any kind and may not be used as such. Advice must be tailored to the specific circumstances of each case. Every effort has been made to assure this information is up to date as of the date of this presentation. It is not intended to be a full and exhaustive explanation, nor may you use the information to replace the advice of your own legal counsel. The presenters assume no liability for typographical or other errors contained in the presentation or for changes that occur in the future affecting anything discussed therein. Next, I'll tell you a little bit about Kaulkin Ginsberg Company. Since 1991, Kaulkin Ginsberg Company has provided critical strategic advice to the accounts receivable management firms. The firm's client-centric approach covers almost every stage of a company's life cycle and enables us to maintain long-standing relationships as trusted advisors. The firm provides mergers and acquisitions advisory, strategic consulting, valuation and financial solutions, market intelligence and analysis, as well as litigation support and expert witness. And with that, we're ready, and I'll turn it over to Mike Ginsberg, President and CEO of Kaulkin Ginsberg Company.
Kelsey, thank you very much. In the interest of time, we have a lot of ground to cover today and only about 45, 50 minutes if we're going to allow for some Q&A at the end. With regard to Q&A, and before I introduce our distinguished panelists, if you have any questions, please submit them. My promise and our panelists' promise to you is we will get you answers. If we don't cover it today, expect an email from us shortly after the webinar concludes, probably within the next couple days. I'm excited to have our panelists here. As you can see on the screen, what I will do is I will let Roseanne, Tim, and Joanne introduce themselves briefly when it comes time for them to speak with you. These are the topics we're going to cover today. As you can see, we have a lot of ground to cover. These go together. We're going to make this as conversational as possible, and we do welcome your involvement through Q&A. I'll start by telling you something you already know, that 2020 is shaping up to be a very significant year for compliance in the accounts receivable management ARM industry. Most significantly, we could finally see an update to some of FDCPA's more outdated precepts through the CFPB's upcoming rulemaking on debt collection. With the comment period now closed, we seem to be in the home stretch of this long, dare I say, drawn out process. Another trend to watch is the constantly shifting standards set by the courts regarding the TCPA and FDCPA. In particular, definitions of an automated dialing system has been subject to sometimes contradictory rulings across the country's various circuits. Roseanne is going to speak about this in greater detail shortly. We're also seeing changes in terms of oversight at the federal and at the state level. The federal government continues to be a mixed bag. The Trump administration has generally committed to deregulation, but Congress has taken steps recently to intensify oversight. One example of this is the recently passed TRACE Act, which amends the TCPA to implement a specific forfeiture penalty for robocalling violations with or without intent, and the extend the statute of limitations for intentional violations by 2 years. Meanwhile, oversight at the state level is getting stricter, particularly in those states where the Democratic Party is in power, such as in New York and in California. As enforcement at the federal level relaxes, these states are trying their best to pick up the slack. Tim and Joanne will dive deeper into this during this webinar. There are also several important Supreme Court cases this year with implementations for the arm industry. We'll be discussing some of those as well. One final trend I'll touch on is that ARM companies should have more room to utilize new technologies in 2020. States like Arizona and Utah have created regulatory, quote, sandboxes that allow businesses to test innovation or innovative new financial products and processes without having to worry about compliance issues. Joanne will discuss this in some depth shortly. With that, I'm going to pass it on to Roseanne so she can begin to discuss the trends in the CFPB heading into this new decade. Roseanne?
Thank you, Mike, and thank you for inviting me to this session today. I'm going to be focusing on some developments with regard to federal oversight. Let's go to the next slide. Thank you. All right. First of all, Mike already touched on the status of the rulemaking. We nonetheless anticipate the publication of the final rules to be this spring. Some people have talked about May, some have talked about July. I think, as all of you know, as we've lived through the past several years, there is no way to literally predict with any degree of accuracy the date, but we do anticipate publication of the final rules this spring. All bets are off, though, when it comes to the impact of the election on the CFPB's decision to release the final rules. One thing is for sure, we do know that, with all, to the extent we can't predict, but we do know that there will be a 1 year period within which affected parties can comply with the new rules. So the effective date will be 1 year after publication in the Federal Register of the final rules. That means that if we are correct and we do see final rules in the next 3 to 6 months, people should be, if you haven't, I've already run into people who have not yet really, they said, well, these rules, they're 500 pages of introduction, in terms of the publication. They said it's 500 pages long, 400 of it is an introduction, 50 pages are the actual proposed rules, and the last several pages are the actual guidance documents. And they've just not given the time necessary to study these rules. To be honest with you, I have people that have asked me, in order to study it, we read it together. We schedule 1 hour meetings a week, and we have read this thing together, and that's actually what it takes. So internally, you may want your ops team and your compliance team to work together to read it together, because it is a fascinating experience and the only way you're ever going to get your arms around these new rules. Let's talk about the fall 2019 supervisory highlights. I think all of you know that the CFPB publishes highlights about their supervisory exams 2 or 3 times a year. And so we thought, in case you haven't read the 25-page fall supervisory highlights, we thought it would be helpful to let you know what the CFPB is telling us. First of all, this particular publication, the fall supervisory highlights, focuses on the nonconformities, the non-compliance activity of both data furnishers and credit reporting agencies. My comments focus on those people, on the data furnisher. Now, just as a matter of perspective, if some of you, for a long time in this industry, everybody credit reported, then it became way too cumbersome, way too risky. Litigation was just mushrooming around this topic, and people decided to stop credit reporting. Some even said, well, it really didn't even have an impact on our lift. Well, I'll tell you that there's been a trend back towards credit reporting, probably due to the relaxation of the CFPB's overt enforcement over this particular law. But nonetheless, there has been a newfound interest in credit reporting. So the CFPB has told us in their advisory comments, or in their supervisory highlight comments, is that by and large, they're noticing that data furnishers and debt collectors in particular are becoming lackadaisical. That's my word, to summarize a whole 2 or 3 pages of comments. Lackadaisical about their compliance management system. Policies and procedures are out of date. Policies and procedures do not reflect new requirements on data furnishers as required by the CDIA, Metro 2, and case law. So they've cited that as a major issue for data furnishers. So if you're going to play, you have to make sure that you update your compliance management system in general, but most specifically with regard to credit reporting. They are very concerned about the handling of consumer disputes, both direct and indirect. They believe that if people would go to Reg V and incorporate Appendix E, and that could be another topic unto itself, another session, that people will be in good shape as a data furnisher. But by and large, what they're telling us is that the procedures can be appropriate to the size and sophistication of your organization. So the small 5-person agency need not function with the sophistication in terms of its CFPB credit reporting readiness as, let's say, a large 2,000-person company. With regard to mortgage furnishers, and by way of example, we learned from each of these sightings by the CFPB, they indicated that dispute investigations were not being conducted timely. People were either basically warehousing these disputes and setting them aside. They were not responding within the required period. With regard to auto loan data furnishers, they noticed that the investigations themselves were actually inadequate. The procedures were insufficient. That the agents were not, the agents meaning the agents examining the disputes and conducting the investigations, were not even reviewing internal records or the client records. So the CFPB finds that to be a major deficiency. With regard to debt collectors, and I think this is the probably of most interest to everyone on the call today. With regard to debt collectors, they simply failed to differentiate between an FCRA dispute, direct and indirect, an FDCPA dispute, and a validation request. There seems to be complete muddiness in the eyes of the CFPB surrounding how people respond to a request for validation versus a direct dispute under the FCRA, indirect dispute through EOSCR, and certainly an FDCPA dispute. All consumer disputes are not created equal, and the CFPB is mindful of that, and with regard to its supervision, is writing organizations up for failing to properly identify unique policies and procedures for each of those kinds of disputes. They also said that agencies are tremendously poor, or they're failing tremendously at promptly responding within the appropriate regulatory time frame to a dispute. And this is interesting to me. They have established a document retention policy. They state that data furnishers shall retain dispute documentation for 7 years. With regard to all documentation and information related to the account subject to the dispute. 7 years. So reconcile this with your document retention policies generally. Consider how do you isolate these and make sure that your document retention policies with regard to disputed FCRA accounts is siloed and accessible. So those are some of the major comments that we're seeing coming from the CFPB with regard to data furnishers. With regard to the new standard for abusive practices, the third column on this slide, on January 24th, the CFPB did not issue a guidance bulletin. Many of you may be aware of the fact that if you're on a RSS feed from the CFPB to receive all information, like to have it pushed to you, you haven't received a guidance bulletin in years. And the reason is they're not writing them. They've gone quiet. You'll remember that the CFPB announced that it is not going to create law or surprise business through the use of guidance bulletins or even enforcement procedures. They believe that they need to stick and adhere to enforcement of the law as written today. But one thing they did say, they did identify on January 24th in an announcement, not really a guidance bulletin, and certainly not in the framework of a regulation. They stated that we are going to make clear that we have a new standard for enforcing the Abusive Practices Act section of Dodd-Frank. Some of you may remember that prior to Dodd-Frank being passed in 2010, which started all of this with the CFPB, prior to that, there was an abusive acts and practices section embedded into the Federal Trade Commission Act. But nobody in the debt collection world really cared about it. It was to be used as an extra hammer when the FTC conducted investigations. It really wasn't part of our world. Dodd-Frank changed that and included an Abusive and Deceptive Practices Act section in the act itself, but then no one knew what it really meant. But and to some extent, in a way, a lot of people in the debt collection world thought, meh, who cares? It's so vague. What is an abusive practice anyway? Well, the CFPB makes clear to us today that if it's a practice that harms a consumer, the harm to the consumer must outweigh the benefit to the party committing the harm. Now, that's about as clear as mud, but nonetheless, they have introduced a new standard that they are going to look at the harm. This almost takes on a little bit of a flavor of the, Joanne, you'll know the cases, the standing, the
Spokio.
Spokio, yes, thank you. It kind of takes on that whole flavor of they're looking at, was this person really hurt or not? I mean, so stop whining about the abusive practices. Nobody really cares, no harm, no foul. There's a little bit of that laced into this announcement. I don't know if my colleagues like Tim or Joanne, if you have any comments or perspective on this before we move on, but.
No, I would just a couple of comments. I mean, I think we saw the director speak in front of the House Finance Committee last week. And I think there was this thought process that with the current administration, somehow the CFPB was magically going away. And that's definitely not the case. And the directors, if anything, has shown more of this independence, if you will. If she's going to do what's right by the consumer, and she's kind of following that path, but she wants to do it in a reasonable fashion. And that's refreshing to be able to see that piece, though some people would say it probably still goes too far. And my concern has always been, if it looks to be a weak CFPB, then you're going to have what Joanna and I'll be talking about later about sort of the states stepping in, right, and trying to fill that void. And just as it relates to CCPA, the California Consumer Privacy Act, you know, we now have this new requirement that you must keep disputes for 7 years. So you have to factor that piece in. There's so many, you know, what can I delete? How do I delete? Do I delete? You know, and all those things. And I just thank you for sharing that, Roseanne, because I learned that today and had to go update my chart to put that reference in there. That if you do credit report and you do have these disputes, it's, you know, you're going to have to keep that information longer, which, you know, is going to definitely impact the rest of your CMS, your policies and procedures. So great information in there. It's going to be interesting to see. There were a few CFPB folks at the RMAI conference. The message I got from them, of course, is they won't give you an exact date, but the quote was, "All heads are down, working on the rule." And so I think that means there's a very tight time frame that we should expect it. I keep saying Friday. I never say which Friday, but I always say Friday around 5 o'clock, because that's usually when stuff gets pushed out. So look for it on Friday. So.
Yeah. Thanks, Roseanne and Tim. And Tim, I think you're right. And just to clarify, there is still a portion of the NPR that we're expecting, to Tim's point, probably this week, and that is the issue of the statute of limitation disclosures. And I think it's important that as an industry, we do look at that and carefully. I don't think anybody's going to be surprised of what is being proposed by these disclosures. There's going to be some sort of language, and to the extent that there are those on the call that do collect out-of-stat debt, it'd be nice to have some sort of safe harbor disclosure, and I think overall people would be fine with that to the extent it doesn't really conflict with state law. But I think the important part of what they're going to distribute is how they got there and what their research and data is going to look like. And we've all had experiences with the CFPB and their data. So I think it'll be really important for us to take a look at that and how they arrived and to make their decision, because my experience is sometimes it's been thin.
Joanne, I have a question for you about that.
Yeah.
In one of those 1 hours where I was reading reading the proposed rules, they have reserved paragraph C of the out of statute debt section of the NPRM. So listening to your words carefully, some people have been saying that what we will see next week or beyond about what we will see is going to be separate and independent from the NPRM. And I thought, as I think you said, it's actually part of the NPRM.
It is.
Comment?
Yeah, no, I don't see it. I mean, it was separated apart to the extent that it was not published with the NPR. What I think they'll do this week is issue what is called a supplemental NPR. And there will be a comment period, and I think it'll be telling to see how long that comment period is, because if the conventional wisdom, and I think you and Tim are correct, is that we want to see a final rule this spring. If they give us a 30-day comment period, then the comments will, be due come March. And then they will incorporate those comments into the, with everything else that they have received relative to the NPR. Now, if they do 60 days, then I think that pushes the NPR out maybe to June or July. But I hope it's not the case. I think my sense, and you all have talked to CFPB folks, my sense is they really, really want to get this to the finish line. Which I think we do too. I mean, it's imperfect, and we know that, but it's certainly a building block and a start to kind of get some framework about how we look at the FDCPA and how we operate under this statute. So I'm certainly anxious and want to see a final NPR, although we can have a whole nother webinar on potential challenges to the rule, but be that as it may, that's another thing. I just also want to comment on the abusive. Many of you may have seen over the summer, the CFPB did a UDAP symposium, which I have to say was one of the better CFPB symposiums they've done in a long time. And there was a really wonderful cross-section of participants, both on the advocate side and industry side, and it was a really healthy and extremely formative discussion. I'm kind of disappointed in what the CFPB came out with their quote definition or their statement of policy. To your point, Roseanne, it's clear as mud. I don't think it moves the needle at all as far as defining it. But however, I do think there was always this question about abusive, of whether it was duplicative to unfair and deceptive. And I get the sense from what the CFPB does is that the abusive now is more of a punitive aspect of enforcement. Now, this is just my sense, and that, they will always analyze facts and circumstances under UDAP for unfair and deceptive. And to the extent that there is something above and beyond that, and I guess that's the balance of the harm to consumer must outweigh the benefit, that's where the abuse is going to come in. It's going to be kind of like the sanctions arm or the punitive arm of how, in my opinion, how they're going to move forward with enforcement. But unfortunately, because the director has taken the stand that the structure is unconstitutional and that she could not possibly have a job come after the election, I think we all have to look at that very carefully, because it isn't guidance. It is a policy that can easily be overturned by the next director.
True. Well, the one thing they did say, you might find this interesting, in that publication that I read about the abusive, about UDAP basically, and how they're interpreting, is that they're not going to, you know how as lawyers you plead things in the alternative, if
Yes.
not this,
Yes.
then that. They're saying, I think this is what you may be observing, they're saying that, no, abusive, deceptive, whatever it is, we're going to just wrap it into one fact pattern, and we will, how did they put it? We will, there are two parts in terms of the end result. We will provide restitution for injured, harmed consumers. But you will only be able to, they'll only seek damages once. They won't seek damages under both abusive and or deceptive. You know what I mean? They'll.
Correct. That's correct. That's absolutely correct.
But anyway, again, it's still rather muddy. But I think this means that although the CFPB seems to be a bit complacent, they're really not. There's a lot going on at the federal level. And perhaps the one thing I suspect, and we can move on to the next slide, we have many other things to talk about, I'm sorry, but the one thing that I suspect, they have locked people down in terms of their ability to discuss examinations. I mean, people are so quiet about it, yet I happen to know last week I found two companies that through a long process found out they were subject to an examination. So I think the CFPB is alive and well examining agencies, larger market participants, but for some reason the gossip and the chatter is not as loud as it was during the early years.
Mm-hmm.
Let's go to the next slide. And in the interest of time and respect to my colleagues here, I'm going to do the TCP update rather quickly. I would like to focus on just a few cases. Let me give you the end of the story at the beginning. The end of the story is that, quite honestly, it's like a lot of things in compliance. What we tell you to do to comply with the law might be more conservative than what your defense lawyer would say she can do if you are sued. So that applies to the TCPA. Good news with regard to defending cases, because we are seeing a trend that more and more courts, all the way up to the 11th Circuit, are deciding that unless your, I'll use the term automatic telephone dialing system, unless the device, hardware coupled with software, has the capacity to generate random or sequential numbers and to dial such numbers, it is not an ATDS. And there is no one in our space that sells a, I'll say, dialer that has the capacity to generate random or sequential numbers. That algorithm does not exist in today's modern day dialers. And so that's why the word dialer, by the way, is not interchangeable with an automatic telephone dialing system, because automatic telephone dialing system, or ATDS, is a defined term under the TCPA, and it is the basis for the onslaught of litigation over the past literally 20 years, 17 years. So anyway, let's take a look at a couple of them. In this one is particularly helpful. We're seeing almost a relaxation, or I'll say, what would be a better word for it? Judges seem to understand the conundrum calling parties are in when dialing consumers. Everyone knows that you need consent to communicate with a consumer by using an automatic telephone dialing system, or pre-recorded message, or artificial voice, including a text message. But the question has always been, well, what happens if the number's reassigned? I got consent from A, and now the number's been reassigned to Mr. B, and now I call Mr. B. What am I liable for that? And in the Sando case, they said, although the text of the TCPA does not really provide for any sort of reasonable reliance, the court is basically saying that we don't require the impossible of calling parties. So, but that this court is basically saying, and a couple of others have agreed as well, if you call the party in reasonable belief that you had the consent associated with that number, you're not in violation of the TCPA. I would not recommend continuing to call that wrong party, but nonetheless, it's a refreshing case from a defense standpoint. Let's see, another case I'd like to talk, Morgan versus Adventist Health System. In this case, it's a great example of when a random or sequential number generator is not evident in the device, it's not an ATDS. The system must have the present ability to randomly or sequentially generate telephone numbers to be an ATDS under the TCPA. There's another case for those of you who collect federal government debt. The exemption that found its way into President Obama's budget a few years ago, the exemption for the collection of federal government debt from TCPA compliance is being challenged at the district court, and now it's moving all the way up. The Supreme Court has accepted and granted a petition for certiorari to review the decision in the Fourth Circuit striking down the exemption as unconstitutional. Basically, they're saying you have to look at the content of the message in order to know what the message is about, and therefore that violates free speech, and therefore it is an unconstitutional exemption. So we shall see, but this is very important for those who collect federal government debt, student loan debt owed to the federal government, taxes, etc. And finally, the TCPA, my words would be saying it's going up in smoke with the Glasser case versus Hilton Grand Vacations. This is an 11th Circuit case. We see an awful lot of TCPA litigation there. This is the hallmark case where it states that at this 11th Circuit level, in contrast to the 9th Circuit, but it says the ATDS must include equipment that dials randomly or sequentially. So the 9th Circuit is still alive and well, telling us that if the device can store numbers and dial such numbers automatically, store and dial automatically, it's an ATDS. But most of these other cases are saying that's a lovely interpretation, but unless it has a random or sequential number generator, it's not an ATDS, period. So, Joanne and Tim. I think Tim and Joanne are doing this. Okay, go ahead.
Yep. Yeah, and Roseanne, nice job with the TCPA there. I think there's some movement, I would say, in the right direction, but still very, very muddy waters that are out there. So, and we have the same with the California Consumer Privacy Act. I'm going to, just for time perspectives, go through just a few things. I want to let everybody know that the latest version of the CCPA regs are now out. They came out on February 10th. They've given us a whopping 15 days to comment on them. So, which is very, very kind of them. The comments are due back by February 25th at 5 p.m. Pacific time. So you on the East Coast can work those late nights on the 25th just to be able to get your comments over to them. I would expect that the final version, and this is open to Joanne and Roseanne, the final version will look very much like this red line version. They fixed some things in there, but I think they've tried to do some clarification. There's been a little bit of expansion. They just came out, so it's one of those activities that I strongly recommend, that Roseanne does with her team, is read through it with others and see some of the changes. Some of it looks positive. I've read a provision in here, section 999.302. It's guidance on regarding the interpretation of the CCPA. It starts out strong. It talks about what personal information is. And that, for an example, if a business collects an IP address, and most of us collect IP addresses, we just don't know about it. Anybody who goes out to your website provider could be capturing that information. You may just not be using it. But if you have that address, it may not be personal information under the CCPA, except that if they put in this clause in here that doesn't really help us, and it's not personal information as long as you're not tying it to a consumer, or it's not could not reasonably be linked with the IP address. And so I go, well, that just throws out that whole provision, because you can easily link a lot of times an IP address back to a consumer. There's scrubs that do it now. There's you can start to capture that information based upon giving specific URLs to individuals that go to your websites to do payments and that stuff. So I'm like, great, you gave us something, but not really. One of the other things that's in there that's not in there that I was really hoping to see was sort of the safe harbor language, if you will. Here's what your notice has to say. And it would kind of give you a little bit comfort, from a bulletproof perspective, that this is the verbiage, this is how you make it clear, and this is how we won't get sued on this or won't have any of these issues. We didn't get that. We got a lot more examples. So I think that's helpful, but we still don't have that bright line, if you will, safe harbor language that's in there. I don't know, Joanne, if you've had a chance to look at it, or Roseanne, you've had a chance to look at it, if there's anything else that jumps out at you as it relates to those.
Not to that provision. There's an issue, again, about record retention. And you have to, keep your accounts for, I think if you have 10,000 accounts, you have to maintain, all those disputes, which is a lot. It came out, we got it yesterday late afternoon, so we just have been poring over it a little bit. But I agree with you, Tim. I think the red line is what you see is what you get. So there's a couple little issues in there. It's and I'm sure, Roseanne, you're knee deep in this, as Tim, you are. It's been challenging working with clients. We all know what it says. It's trying to revamp operations that has really been a challenge. Because while I'm sure everybody on this call has robust policies, procedures, has privacy procedures, has an operational infrastructure, this is just a new element now that you have to kind of, fit in. And that's a challenge with not a lot of time.
And the other comment I have is, it's unfortunate, I guess. At the same time, we're going to be talking about innovation in a little bit, but at the same time that we are just throwing ourselves into how can technology assist the debt collection industry or even the credit industry? How can AI, artificial intelligence, really serve as a game changer to the consumer experience? All of this is going on, but then, oh, by the way, but you're going to have to like pull data out from the recesses of a AI experience. You know what I mean? And I find it to be two worlds colliding, and I don't know who's going to win.
I agree. I think it's really going to come down to that consumers are going to help drive some of that. I mean, there's consumers out there that don't necessarily care about privacy, and there's other that very much care about privacy, especially as it relates to financial, medical.
Do you guys happen to know, can you in California, can you buy a consumer's data from the consumer? Like, here, I'll give you $2.
Do not know, but that would be a great business model. Let's talk about setting up that company as soon as we get off this call, and we'll go from there. Because there'd be people out there who are willing to sell it. And really, that's kind of what the whole purpose of that CCPA was. It's really not the small players. It's the big players they were going after. They were using all this data to be able to make all their money, right? And so, and we were giving it to them freely. I mean, Gmail is not free. Google is not free. And yet the expectation is, so how do you make money off of it, but not make it to the point where, every time you go online, you get a pop-up. But just to be able to move us on just a little quicker here, I think one of the things that going through this process, and Joy made a great point, is like, how do you operationalize this stuff? And it starts off with some basics. One of the things that's not on here is your information security program, right? So you really, if you're going to spend time and effort as it relates to privacy, that's where you need to do it, because the state attorney general doesn't have a lot of funds to come after you to go look at your website or do any of that stuff. You're going to bubble up because of complaints, or you're going to bubble up because you have a data breach. The last thing you want to do is have a data breach. So first and foremost, that's where you should be spending a significant amount of your time and a significant amount of your resources, is hardening your systems and making sure that technology allows you to not only encrypt but tokenize and do all those things that prevent a data breach. Because when you have that, you're going to have to tell the State Attorney General of California, and they now have a hammer that they can use on you with significant penalties. I just read a report last week that the cybersecurity coverage is going up dramatically in the state of California because of this. So we can expect that to go up even further other places. But some real basic tackling here is updating your privacy policy on your website, because it's out there, right? So it's easy to see, it's easy for consumers to see, plaintiffs' lawyers can see it. It's probably at the very, very bottom of your website. It was probably the original one when you launched your website. Needs to be updated. There's some state requirements out there that says you have to keep not necessarily just in California, but in other states. If you have an old privacy policy, you have to make sure that it's still available so people can see what changed, those kind of things. Having responses to the consumers, and that kind of fits into, okay, what am I going to do? You don't have to have it all typed out and all figured out and out to your mail vendor, because we really haven't seen an influx of huge volumes. Everybody was concerned that it was going to be like cease and desist, and we were going to see a percentage of those and people were going to use it for that. We haven't seen that. At True Accord, we've had one. We were super excited when we got it because it gave us a chance to actually test the process. We were overly excited, from a compliance geek perspective, that we were able to walk through it, and so, but some of those key things, and Roseanne talked about it, when you have this technology, it's like, where is the data? How does it come in? It goes from the very beginning, from when that file gets placed, that's data, all the way through to, do you enhance it? Does it get enhanced by the consumer? Is the consumer opening emails and you're capturing information, or are they updating stuff on the website? And all of these things are just tracking it all the way through to the life. So if you have a request and it fits into your policies and procedures that you're going to delete, then you would know where that data is, so that when you respond back to the consumer and say, hey, look, we deleted it, you actually did. And you got it from backups, and you got it from everywhere where that piece of data is. So some of the best practices are dedicated teams. So right now we're filtering all of these through compliance. We train the floor if they have it. All of our intake sends it to compliance. It doesn't go to the floor. If you get a call on it, there's a 800 number you can transfer it over to. Get it over to the experts. This is going to be a big part of our clients' requirements going forward, and expect that they're going to want to make sure that their vendors, who we are as agencies and stuff, are in compliance with it, but also our vendors, of the vendors, are in compliance with it. And I would be sure to add it to your, internal audit plan for 2020. It'll set you up perfectly to say, okay, let's go see if we got them. Do we process them correctly? You can find the gaps and those kind of things there. So just a few simple takeaways there. If we can go on to the next slide. I'd like to tell you that the world the news is getting better. It's actually not. What we're seeing as it relates to privacy is what we saw when we had the CFPB come on board. Compliance before the CFPB was really driven by our clients, and that might have been by the OCC or maybe some of the FTC. Today, it's the CFPB. Everybody has a compliance department. They have a CMS. You're going to have the exact same thing as it relates to privacy. So get ready for it, right? Privacy is going to be a cost of doing business in this space. We have Hawaii, Maryland, and Virginia who are coming on board. There's others every single day. I heard of another one today. Can't remember it off the top of my head, but New York and Washington. They're going to be looking at California. New York and California are in a competition to see who could be the strictest. They do it for bars, for the state bar exams, and they do it for everything. So I expect, private rights of action, higher penalties. New York will be the standard, and then we'll see California adjust their standard and such. In the meantime, you'll kind of have a range of all over. People are looking for sort of that Hail Mary pass from the federal level. So the federal government would pass a privacy law. Seems like we're down to two issues. There's definitely some interest there. There's a lot of money coming into Washington on this issue. The big players, Google's, Facebook, they would love to have one standard. The issue really comes down as there's a party that wants a private right of action, and there's another party that wants preemption. And so I think private right of action is probably easier than preemption, because I think there might be some concerns from a constitutional basis about trying to pass a federal privacy law that preempts all the states. So don't want to go into too much detail around that, but some of the things that you can do is, sign up with law firms like Joanne's law firm, keep in touch with people on the stuff that's happening with privacy. But first and foremost, fortify your security program, just so you're able to stay off the radar. So shoot any questions over that you may have on that. Quickly over to my panelists. Anything else that I may have missed? It's very, very broad. There's a lot of stuff there, but. Nope. All right, excellent. Move along. All right, stricter oversight in the CFPBs. Joanne and I are going to be talking about this. I'll just refer back to what Roseanne talked about. There appeared to be a weakness at the CFPB, right? So there's vacuum. Because of that vacuum, we saw states start to step up and try to fill that void. New York, first and foremost, comes to mind. And Joanne, I'll kick it over to you if you want to talk a little bit about that in New York and your perspective. We don't have anything yet, so it's still in the preliminary stages, but I would expect that we're going to see more of this.
Yeah, thanks, Tim. You know, you talked about the perceived weakness. I think for all of us who have clients who touch the CFPB, I think sometimes I see that as a false narrative. I still see the CFPB as active, yes, and even the amount of enforcement actions, you know, maybe they're not as high as they were before. I know there's been criticism on restitution and civil penalties, but the CFPB, certainly under Director Kraninger, is active. They are still doing a lot, but it was when Mick Mulvaney came in where he really kind of baited the states in a speech that he gave after the first couple months that he took office as acting director, and said, you know, states are in a much better position to do enforcement. You know what's going on in your states. You should be doing it. Well, you know, certainly New York and California have taken that to task, and other states as well. To your point, Tim, that first year after Director Cordray left, there were a few states that really enhanced certainly either attorney general divisions or their financial regulator divisions. In Pennsylvania, they have the Consumer Financial Protection Unit that's run by Nick Smith, who's a former CFPB enforcement assistant director. New Jersey has enhanced their AG's office with the Consumer Protection Division. Maryland. So you started to see that ramp up right after Director Cordray left. And now with Director Kraninger, you see states taking a more active position. And yes, I mean, DFS has always been a very aggressive regulator. And as many of you saw in the news a couple weeks ago, Deandra English, who is a former CFPB, worked at the CFPB and for a time had claimed that she was the appointed director from Richard Cordray, but nonetheless has left and is now a policy advisor with the DFS. So they're all taking a page from the CFPB playbook, and they want to model the culture and operationally at the state level what the CFPB did. And I think what's interesting about New York, first of all, last April, there was an announcement that they were beefing up enforcement. So that New York has come out at the beginning of the year and said, you know, we're going to be really aggressive in the financial services space was not necessarily news, because they had been very aggressive and were going to start being very aggressive on the enforcement side of things. But I think what's interesting about New York is one of the proposals that Governor Cuomo made is that they are going to start licensing collectors. We have licensing in New York City and Yonkers, but now there's going to be statewide licensing. And while some have said, you know what, look, fine, I don't want to have to worry about different boroughs and whether I'm licensed or not, and there's a uniform license, great. But understand that once you license, you give basically the keys to the asylum to the inmates. And right. They're going to, you know, they are going to, if you license, they have a right, and they have said in their proposal that they have a right to inspect your records and come on site without notice. So that's exactly what they're going to do. So while people in New York already have enhanced compliance procedures, don't take your foot off the gas there. I mean, continue to have high and strict standards, because DFS could be knocking at your door. I think what's interesting, and this kind of ties in a little bit with what Roseanne was talking about, and we'll talk about this a little bit in California, this whole idea of abusive is now seeping into kind of the state psyche. If you look at the proposal, Governor Cuomo's, again, proposal, the recommendations are to prevent unfair, deceptive, and abusive practices in the consumer protection space. So the states are now going to weigh in and define what is abusive, which can be a little scary for the same reason that we have a California CCPA and we could have a Washington equivalent or some other state. You know, what are those? There's not going to be a uniform standard, or at least, you know, I hope there is. But the conventional wisdom is if each state is going to interpret what's abusive, you could have 50 different interpretations. So I think that's something that as an industry, we really need to pay attention to, especially if you have.
So too. And Joanne, for example, the 7 and 7 rule under the proposed rules, that just to summarize it for purposes of call frequency and
Yes. Mm-hmm.
the state is a, this is a shield from liability should you comply with this requirement under the federal law.
Right.
But that doesn't mean it protects you from a state restriction or that's more restrictive, or a state's interpretation that if you call, because you have 7 accounts and you call them 77 times in one day, that's not abusive, right?
Absolutely. And to your point, Roseanne, if you look at the proposals, New York is proposing a similar call cap to what Massachusetts has.
Yeah, okay.
They're doing it 2 times per day for 7 days a week and no calls at work. So, again, the states, again, and I think that is a direct response to, unfortunately, what has been an overwhelming disapproval by consumer advocates of the NPR, which, again, I can't fully wrap my hands around. I understand certain aspects, but I think that's a state, you're going to see states like New York and California who will respond to what they believe should be better rules involving debt collection, and they're going to do it through legislation, and that is going to create some operational challenges for sure. Tim, you want to talk about California since that's where you're perking from?
Yeah, I'm just gonna, because of time, I'm just gonna say one word: Cordray, and that's all you need to know. So he is currently involved in California and advising there. So what we've seen sort of as a formation for the CFPB, I would expect that we'll see something very, very similar. And to your point, this unfair and deceptive practices, imagine having 50 different standards of something that's already pretty hard to define.
Right.
So, but I think we're going to expect to see licensing. They want San Francisco is a huge fintech space, so they're going to definitely want to see some oversight over the innovation and stuff that's going on there. So, time will tell. Both were, I think, were proposed in budgets. It'll be interesting to see what the final budgets look like. I would expect we're going to see something. They've got, I think, around $41 million earmarked right now for California. So I think the funding could be there for them to set up, and they're going to ramp up from 14 to 90 people, by 2023. So they've got a pretty good idea what the recipe looks like. They just need the oven to bake it. So
right. I think it's so the financial regulator in California, Tim, as you know, is DBO, was the Department of Business Oversight. The proposal is to change that name to the Department of Financial Protection and Innovation. Okay, fine. But what's interesting is and I'm going to talk about this in a minute, when the policy initiatives for Sandbox, No Action Letter, all of that stuff, the innovation stuff came out, there were many AGs, including the AG of California, that came out in absolute opposition to these innovation proposals. So while they're going to have this regulator that's going to have oversight over innovation, it's going to be interesting to see how they're going to balance it. And I think to your point, and we might have talked about this before the call, it's really hard to do business in California right now. It's expensive. It's hard to attract employees. The cost of living is high. How much California is going to ease restrictions on innovation from a regulatory perspective, given the AG that they have, given who's making up the current California DBO, is going to be interesting to see. It's not going to mirror Arizona. It's not going to mirror Utah. I think it's going to be, while they're going to want it, I think that regulatory regime is going to be a lot stricter than other states.
Agreed. Okay, should we move on for time?
Yeah, let's move on. And speaking of innovation, it's a good segue. So back in September, the CFPB came out with its final policies regarding the regulatory sandbox, the trial disclosure program, and the no action letter. And again, you've been seeing this in Arizona, Utah. It is also in North Carolina, a couple other states. this idea of trying to open the doors and have some sort of engagement with innovators in the financial services space certainly has been a priority of this current administration, and the states are doing that, are kind of taking the lead on that. But the CFPB wanted to get involved, and they developed what is called the Office of Innovation, and it is to offer innovative technologies opportunities to work with the CFPB under somewhat relaxed regulatory burden and some certainty. You will recall when the CFPB first opened its doors, it had what is called Project Catalyst, which the intent was the same, but unfortunately the implementation was not. There was an ability, the CFPB would not agree to not supervise or not enforce. There was going to be a lot of information sharing, and there was not one company that actually got into Project Catalyst. There has been one company right now, which is called Upstart Network, that is doing a project with the CFPB right now, which is a payday lender, and it's a lending arm, and they're finding that different underwriting standards are actually encouraging more access to credit, and the CFPB has posted some reports on that, so I think that is encouraging. But for our purposes, this Office of Innovation is open, and the CFPB is very much looking to talk to innovators in the financial services space to see how that they can partner. Now, what does this mean for the ARM industry? It's limited. I will tell you first that for the sandbox, the final policy only applies to ECOA, TILA, and EFT, Electronic Funds Transfer Act, because those particular statutes have a statutory safe harbor, which say if a regulatory agency, gives you a safe harbor or is given the authority to issue a safe harbor, that's how they ultimately get in the sandbox. So it's not available for the FDCPA, but that doesn't mean that it shouldn't be. And it doesn't necessarily mean that there has to be a legislative fix. There are other opportunities within the FDCPA that say that a regulatory agency could somewhat give a safe harbor. In fact, the statutory, if you look at 1692 KE, it says liability shall not apply to any act done or admitted in good faith in conformity of an advisory opinion of the CFPB. The final policy that was issued in September did not do an exemption by order, which would fall under this aspect of the FDCPA. But that doesn't mean that that policy could not change, and the CFPB could decide and change its policy and allow statutory exemptions, or exemptions by order, I should say. And I think as an industry, as we're really starting to get in the technology, because while we have had it, we've now been afraid to use it. But as technology is expanding in the ARM industry, I think that is a point of engagement that we should be involved with the CFPB to expand the opportunities for the ARM industry to get into the sandbox. So that's something to think about. But there is now a trial disclosure program and a no action letter program, and it does help with regulatory relief as far as supervision and enforcement. And I think that the NPR is ripe to approach the Bureau about alternative ways of communicating with consumers or otherwise complying with the FDCPA that would not harm consumers. So even if the NPR comes out tomorrow and we know kind of, what the final rule looks like, maybe you could go back to them and say, I'm going to test an e-sign provision. I have a different type of validation notice that I would like to test. So I think that there's a lot of opportunities there to work with the CFPB to enhance and to make the NPR better through these types of proposals. So I would strongly encourage all of you to think about your operations once the NPR comes out and see if there's ways to do it better and in a very, controlled, tested environment where you would not necessarily, obviously expose yourself, to a potential wide class action. But I think that those opportunities are definitely there for the industry, and it's going to take, obviously a lot of internal discussion and discussion with the Bureau, and they have been extremely open to having those discussions with industry.
All right. Thank you, Joanne. Those are great comments from both of you. And I'm just going to wrap up with a very narrow topic that can really cripple an industry, a business, for example. Convenience fees. All I really want to get past that is that there's nothing convenient about convenience fees, number one. Some people say, well, is it convenience for the consumer or for us? So it doesn't really matter. The fact is that you can see in this slide, there are 4 types of fees. Convenience fees are the fees that are typically and have been typically charged by debt collectors. Let's go to the next slide. What I would like to share, and this may be difficult for some to understand, but let's look at the right side. When a fee is charged by a third party, no, let's look at the left side. I'm sorry, forgive me. I'm a little under the weather. When a fee is charged by a third party collector, the FDCPA applies, period. Look at across, compare it to, if it's not charged by the third party collector, the FDCPA does not apply. It seems like an obvious statement, but it's one that seems to be blocking one's ability to understand the new fee regime we are in. When a debt collector assesses a fee, let's say for processing a credit card or a debit card payment, they must offer a free option. The fee must be a flat fee and a reasonable fee. It cannot be a percentage. That's a result of the Visa MasterCard rules. Unless you are a government like the federal government and state governments and local governments, they do, as a matter of the Visa MasterCard rules, they are permitted to charge a percentage fee. So that's why when you pay your taxes online, they can assess a percentage. But that's not true for third-party debt collectors, flat fee. And the statement that the consumer receives each month must combine the fee and the single payment as a single charge. That's one transaction. In contrast, there are companies in our space who have brought the solution to us called, there are many different marketing phrases used for it, but it's the opportunity to let the third party charge the fee and keep the debt collector clean and out of the fee business. And in this case, the FDCPA does not apply. You don't sit around and talk about state collection laws because the debt collector is not charging the fee. They still should offer the free option as a UDAP requirement. Again, they have to comply with their own Visa MasterCard rule agreement, and it should be flat unless it's government. And the fee should be a separate charge, because what you are really assessing, the fee in the context of a third-party processor charging it, they are selling a service. I mean, Tim at True Accord, they sell a certain type of consumer communication technology for creditors and debt collectors to use. Joanne sells, she's a great lawyer. She has a law firm. She sells legal services. I'm part of a technology company. We sell technology software. Third-party processors sell the service of processing credit card payments to the consumer. And if the consumer wants to pay by credit card, then they can pay the third-party processor. Now, all of these come in, leave us on that note, but all of this needs to be, you need to confer with your own legal counsel, because I think most of us in this space, the third-party debt collection space, shy away from ever recommending a convenience fee only because of the litigation ramifications surrounding it. If it's not done properly, if it's not documented properly, if it's not permitted by law, the FDCPA tells us you can only charge a fee if the permission to do so exists in the underlying contract between the consumer and the creditor, credit issuer, or it's permitted by law. So absent those two scenarios, debt collectors can't charge convenience fees, henceforth the entry of the third-party processor.
Yeah, but I would just add real quickly that it's of interest to the CFPB. So during your examination, if you check the box that there's convenience fees, involved, and it's a hot point for them to be able to come in and take a look at it. I think, Rosanna, gets to your point why so many agencies have kind of pulled back from that, because it's just, you're already
It's
going to be
muddy.
saying it's muddy. It's
It
absolutely
is.
muddy.
Last August, or maybe it was the August before, I literally went to the CFPB and had a sit-down meeting with them. It's considered informal, and they've everything about what I'm going to share is close to useless. But the point is, I begged them to expand their guidance bulletin on convenience fees. Begged them to clarify how the third-party processor can work within the third-party debt collection industry. They feel their guidance bulletin was adequate, and that is why I am so concerned that people understand and do not blur the duties between when you charge a fee and when they charge a fee. But I think you're right. I know you're right, Tim. It's an area of great interest to the CFPB. I just don't see them offering much guidance on it, and it's silent in the NPRM, other than UDEP.
Yeah.
Yep.
Yep.
Okay, we've gone over the time. If there are any questions, we will make sure that we answer them shortly after this call. Roseanne, Tim, Joanne, you guys are wonderful. You did a great job. Appreciate it. This was without rehearsal, folks, so they were able to collaborate, and I think they presented very important information this afternoon. We will be providing this recording to everybody who participated very shortly. Panelists, thank you very much. Kelsey, thank you. We hope you have a great week, and we'll look forward to talking with you online again in the future.
Thank you.
Thank you.
guys.
If you need to reach us, here's some contact information. I'll be happy to pass it along to any of our panelists or make sure that we answer any questions for you. If you need this information, here it is. Thank you all for your time this afternoon.